Money laundering cases are some of the most difficult cases to defend in federal court because there is so much evidence that's involved. I'm not just talking about evidence that incriminates the client, but you're usually dealing with just volumes and volumes of financial records, in addition to other evidence that shows some tie into the illegal activity. Most money laundering cases are going to face a maximum penalty of up to 20 years in prison. But the most important thing for people to realize is that with any federal case, when we say up to 20 years in prison, there's no parole in the federal system. Most people that are sentenced in these cases to 5, 10, 15 years in prison, they're doing 5, 10, and 15 years in prison for simple involvement in a transaction and receiving funds that come from some illegal source, whether it's pushing for a dismissal or reduction in charges, whether it's pushing some sort of a favorable plea bargain. I will fight and do everything I can to win a trial if that's what it's going to take to get them the outcome that they deserve. The Jesse Quitron case was a case where my client was accused of money laundering as part of a massive investigation by multiple federal agencies into the Zeta drug cartel. And when I first took on that case, I was led into a room with boxes and boxes of evidence. But I approached it the same way that I had learned from previous trial experience. I prepared, learned everything I could about the legal issues, and develop a compelling story to convince a jury that my client had no association with money laundering. To walk out of the courtroom with an acquittal is a very satisfying feeling. I want to help clients move on with their lives. I've had high-profile cases where I've had to go and explain that this was the right verdict in the case because I want the public to see. I want what's on the internet not just to be about what happened when my client was charged and accused with this horrible crime. I want the public to understand that an acquittal was the right outcome, that was justice in the case. So whatever efforts it takes to help that client get back to where they can live their life normally and free from the restrictions and the burdens that the criminal trial brought upon them, I want them to be able to move on with their lives. The skills that I earned from my experience were of benefit. The skills were there, the talent was there. It could be applied whether I had prepared for something for 2 or 3 months in a row. I've seen and know what works and what doesn't work. And so I'm taking that knowledge from having tried all these cases as a prosecutor and applying them in my own practice as a defense attorney. There were moments in that trial when witnesses would begin testifying about my client, and I didn't anticipate that these witnesses were going to offer up evidence. But because I had prepared and I knew the facts of the case, I was able to immediately respond and deal with those issues and cast doubt on what these witnesses were trying to testify about regarding my client. There's really 2 elements to a money laundering case that you have to attack that involve not just witnesses and involvement in criminal activity, but what do the financial records show regarding the client's knowledge of the transactions and involvement with the transactions. Sometimes law enforcement might think that a client is involved in a transaction when in fact they never were. There might have been other individuals involved. Having knowledge that the funds were obtained unlawfully is a critical element to money laundering cases. By being able to show that my client did not have any knowledge of the source of the funds, or more importantly, that my client knew that the funds were obtained from some illegal activity, that is a very common and valid defense that's raised in money laundering cases.